The Adoption Law Reform in Aotearoa by Group 22. The purpose of adoption is to provide a permanent family life to a child who can or will not be provided for by their birth parents. When displaced, the legal relationship between the birth parents and the child is permanently severed. An alternative to this process is a parenting order, where adoptive parents have the legal responsibility for the daily care of their tamaiti, similar to the Māori custom of whāngai. Whāngai involves extended family members raising children instead of the birth parents. These practices differ between hapu and iwi, but are an overall vital aspect of te ao Māori. Unlike the severing birth relationship in the Adoption Act, a whāngai adoption values whakapapa and the links to ancestral lands. Pursuant to tikanga values, a child should be raised with the knowledge of where they came from and who they are. Whilst the Aoranga Tamariki pay regard for these beliefs, the Adoption Act is not supportive of whāngai adoptions. The current statute does not account for Māori values and has led to identity struggles and feelings of alienation within Māori children raised in closed Pākehā adoptions. Family law in Aotearoa is governed by the multiple statutes above. The Adoption Act was developed under vastly different societal attitudes from what is considered appropriate today and is presently described as flawed beyond reform, contravening other family law legislation. The courts are aware of issues, however, have taken the stance that any amendment of the Act is a matter for Parliament. Through this inquiry, we will address the issues and put forward ideas for the urgently required reformation of the Adoption Act.
A good parent in the eyes of the Act. The mother's sole consent is sufficient to allow the adoption of a child. Despite the central role of the mother in the process, the term birth mother is not defined in the Act. Common law currently recognises the woman who gave birth as the birth mother, but birthing the child and being the legal mother of the child are not simultaneous factors anymore. For example, where the egg donor and the prospective adoptive mother of the child is denied the consent of the surrogate mother, whose consent is prioritised. Our law does not accommodate these questions.
Section 7 states that an unmarried birth father's consent may only be used where expedient. The Human Rights Tribunal declared this provision inconsistent with the Bill of Rights Act. Requiring a father to be married to speak for their child unnecessarily isolates the child. This provision also extends the court's powers to act beyond facilitating the adoption of the child, but to determine the worthiness of a parent to remain a parent to the child. This provision also places spouses in a civil union or a de facto couple in a grey area as well. Whāngai. The Act's assumption of a nuclear family is not compatible with Māori ways of living, where the strength of their community is dependent on the bond between its members. Under tikanga, a child does not belong to the parents alone but to a descent group. To ignore whāngai and to isolate other familial relationships of the child is inconsistent with our international obligations. Consent. One requirement is to obtain the mother's consent after 10 days of birthing. 10 days was sufficient time to ensure the mother does not disappear from the hospital after giving birth and leave the child behind. This is outdated. The law does not require the mother to obtain counselling or advice from social workers, despite recommendations from the Law Commission. On the other hand, this requirement does not extend to the child, which is concerning given the Act defines children as those up to the age of 20. In New Zealand, when you're 18, you can vote and have children of your own. Therefore, it's concerning that an adult by many means is not required to consent to their displacement.
The Adoption Act 1955 continues a shame ritual towards unwed mothers under the guise of protecting children from having to reckon with their biological mother's moral failing. Not only does this perpetuate a social understanding that is no longer predominant in society, but it also guillotines the legal connection between the biological mother and child, as well as preventing a child's deeper understanding of themselves. The Act assumes a flawless and emotionally shallow adoption process. However, the guillotine is not without its wounds. Surrogacy and adoption for couples is a lengthy and emotionally draining process. Anecdotal evidence shows that the cost of surrogacy can reach $40,000, and the wait time for adopting one's own child can be months. For same-sex couples, the cost is prejudicial. By nature, same-sex couples are already at the mercy of the cost for surrogacy, and to secure public funding for surrogacy, they must fulfill several requirements, which can be a long and exhausting process of evidence. The gendered nature of the adoption scheme has created barriers for adoptive parents as well as the adoptee children. Specifically, Section 4 prevents single male adoptive parents from adopting a sole female adoptee child unless the court is satisfied that they are the father of the child or if there are special circumstances. Additionally, the gendered language used in the Care of Children Act discusses mother and father under Part 2 of the Act, not having caught up with the 2013 changes to the Marriage Act. Gendered language acts as a discriminative feature towards single men as well as same-sex male partnerships where one male brings in a female child from a previous relationship.
To avoid these issues, we've come up with the following reforms.
The terms birth mother, non-legal guardian father, and birth father that are present in the Act are based on presumptions about conventional nuclear families. These terms may be restrictive and fail to recognize the variety of modern families, which can include same-sex partners, surrogates, single parents, and other situations. The Act and the wider public would benefit from accommodating different family structures such as those involving whāngai arrangements, which is the traditional Māori practice of adoption, surrogacy, and egg sperm donation by substituting language that is gender neutral for gender-specific phrases. We propose replacing terms such as birth father and mother with the child's immediate carer. This phrase is inclusive of all people who act as parents, gender neutral, regardless of their legal status or biological relationship, and defining these terms precisely is important to avoid confusion. Drawing from global standards like the World Health Organization and the United Nations of Conventions on the Rights of the Child, the definition might consist of, first, any person, whether by biological relationship, legal guardianship, or cultural practice such as whāngai, who takes on the responsibility of caring for the child on a daily basis. Second, those who help raise the child by donation of egg and sperm, surrogacy, or other modern reproductive techniques.
Section 19 should be modified or repealed as Māori practices would be respected and integrated into the legal system. Aotearoa would recognise Māori adoption practices by allowing whāngai parents to be included in the definition of immediate carer. This would guarantee that carers are legally recognised and are able to carry out their parental legal rights and obligations. Under our second reform, we propose that an adoption authority be established to administer the assignment of social workers to adoptive families. This will allow the monitoring of the adoption process from beginning to end, which will enable both the parents and the state to maintain transparency. We propose the current 10-day period when a mother births the child and consents to its adoption is removed and replaced instead with a mandatory 4-week period applicable to all non-surrogate parents wanting to place their child up for adoption. Further, we suggest that when a parent makes the decision to place their child for adoption, they lodge an expression of interest to do so with the authority. The 4 weeks will begin from the date of lodging this expression of interest, an EOI. This timeline is similar to the UK's Adoption and Children Care Act 2002, which considers consent given within 6 weeks of the birth of the child.
At this time, we propose that counselling services for the parents are arranged to ascertain their mental capacity to make such decisions. A social worker should also be assigned in this time to collate a report on the child and its family to assess the needs and interests of the child. The social worker should also ascertain whether whāngai arrangements are operative for the child. If yes, the social worker should always assume that the child remains with the family member, unless there are concerns for the child's welfare. We propose that New Zealand include a similar provision to Norway requiring that children above a certain age to consent to their adoption. This would clarify the needs of the child and outline their concerns, therefore allowing New Zealand to uphold the child's best interest. Given the retraction of boundaries for same-sex couples and other facets legally and policy-wise, as well as a social shift, our reform is that there is no reason why there should be further hoops for same-sex couples to jump through in order to seek surrogacy arrangements. A same-sex couple's eligibility for public funding should only be restricted by the same as those placed on heterosexual couples. Given social understandings, as well as several legislative frameworks using gender-neutral language, gendered language in legislation is no longer a one-size-fits-all. This is also applicable to the Care of Children Act, as seen in Section 4 of the Act. Removing gendered language can prevent further shaming for women and address the ever-changing nature of what we consider standard relationships. The bill improving arrangements for surrogacy, Section 22A Amendment to the Status of Children Act 1969, changes the surrogacy scheme, which currently requires intending parents to go through the process of adoption. As part of the amendment, once a child is born, the intending parents automatically become the parents of the child. We recommend that this is passed to simplify a tedious and bureaucratic process that parents currently expecting children via surrogacy have to contend with.
Application of the current adoption regime in our proposed ideas. To further explain our criticisms and reforms, we have created the first scenario on the slide. Under the current regime, there is no mechanism to address Aroha's mental health and determine whether the consent provided is with mental capacity. Due to her age and apparent lack of understanding, Maya does not need to agree to the adoption as per Section 11b. The court will consider Maya's best interest, but she's not actually involved in the process. There is no social work or psychological report to make an informed decision. The Act does not have any inclusive terms that talks about whāngai arrangements. Therefore, Maya's family members would need to comply with the standard court assessment.
Under a reform, Aroha would initialise the adoption process by lodging an EOI with the adoption authority and will be required to complete a counselling assessment via her mental health capacity. Due to the mental health issues, this would be beneficial to determine whether the adoption should take place. A social worker will be assigned to Maya to ascertain her physical and mental needs, centralising Maya in the adoption process. A critical aspect of the reform is the recognition of whāngai arrangements and the preservation of Maya's connection to her whakapapa. If a suitable whāngai arrangement is identified, it would allow Maya to stay within her whānau, providing her with the stability and continuity that she needs, respecting her identity.
Please refer to the slide for our proposed second reform.
Under the current regime, Luke and Mark will face difficulties in adopting Miso due to being in a same-sex de facto relationship because only one of them can adopt Miso, first as her biological father. The other would struggle due to Section 4, subsection 2, subject to restrictions on male parents adopting female children. Because a surrogate mother would be considered the birth mother under the current Act, she can withdraw or deny consent within 10 days of birthing Miso. This would leave Luke and Mark with no legal mechanism to protect their interests as Miso's parents.
Implementing the term immediate carer of the child would recognise Luke and Mark as Miso's immediate carers without the law requiring them to go through a difficult adoption process, given their roles as intended parents from the outset. Our reform also promotes the notion that same-sex male couples will receive equal treatment under the law, aligning the adoption process of modern family dynamics. The repeal of Section 4, subsection 2 would remove any additional legal barrier, simplifying the process. Furthermore, this reformed surrogacy scheme will include Luke and Mark's surrogates' rights as parents. Woo!